Hi, it's Jared Pickens here for Finance 6300. Today we're going to do our 5-minute finance series. And today we're going to focus on probably one of the most important, if not the most important subject in financial planning, and that's estate planning. Now, many of you think that, well, no, estate planning, that's for someone like Warren Buffett, or that's for someone like Steve Jobs, who has a lot of a high net worth. But we have Dusty Wallace with us here today. She's a certified financial planner with Lee Financial Corporation here in the Dallas-Fort Worth area. She serves as the Director of Financial Planning. And Lee Financial, a little bit about them, they've been around for about 40 years. So, and they manage close to about $1 billion in assets under management. So they're a pretty established firm. Well, what Dusty's going to do today is come in and tell us the important things about estate planning, some of the things you don't want to miss, and why you need to have a solid estate plan within your financial plan. So welcome.
Thank you.
Welcome. We're glad to have you. I actually know Dusty a little bit. She also volunteers at the Dallas-Fort Worth Financial Planning Association. So what do you do there?
I am the director pro bono,
Okay.
and so we try to get out in the community and teach some financial literacy.
Yeah. So it's all about kind of financial literacy. Dusty doesn't know this, but this is a service course really to help MBA students get a good grasp of their personal finances. So we're glad to have her here today. So let me get to the really, really difficult questions for her. So, all right. So estate planning. Who's it for? And I mean, is it just for the rich?
Estate planning is for everyone. Whether you have a lot of wealth or you are working towards having a lot of wealth, it's really important to set up an estate plan so that you can direct how your assets go if for some reason something happens to you. Having children makes it even more important, even if you're still building that net worth. Otherwise, the state directs how they go through intestacy laws.
So the state tells where your money goes to.
Correct.
Okay.
So if you're married and you have children, then a third of your estate gets to go to your spouse.
Okay.
But the rest of it goes to your children. And so,
Okay.
you know, your spouse is not really getting to inherit much of anything if she needs support, or he. And your
Right.
children, if they're under 18, are now all of a sudden coming into ownership of assets that maybe they're not ready
Okay.
to manage themselves.
So creating an estate plan would fix that problem.
Would fix that problem. You could
Okay.
leave everything to your spouse, and if your spouse predeceases, maybe create a trust or something for the children, especially if they're underage.
Okay, we'll get to wills and trusts and the difference between those here in a moment. So, state of Texas is one of what, 9 or 8 states that's a community property state?
Correct. I'm not sure the number. It's either 7 or 9, something along those
Yeah.
lines. But
Just numbers.
yeah.
So, tell me a little bit about community property and why it's important.
Sure. So in the state of Texas, it's actually done through the Constitution.
Okay.
And it defines separate property as property being owned prior to marriage or through inheritance or gift. Otherwise, everything else is considered to be community. In other words, the spouses share their property half and half. And it doesn't matter who earned it or purchased it. As long as you were married at the time, there is a presumption of community property, and it can be difficult to
So,
overcome.
even if you have a spouse at home that doesn't make any income or anything, the IRA that you contribute to, you're deemed 50% ownership from both spouses,
From
right?
both spouses, regardless if the other spouse at home is not actually out there in the career world earning
Okay.
the money and putting
Okay.
it into the IRA.
Okay. So I think that's important for Texas residents. I know Arizona and a couple other states. So look at your state to make sure you're either in a community property state or not. So, so let's talk a little bit about the estate plan. What documents are the most important for somebody to have in an estate plan?
You definitely want the will, especially if you have children, so that way you can name guardians of your children if they're under age 18.
Okay.
Those are the people that will watch your children if both of you happen to die prematurely. And then the other really important documents that are out there are what's known as the ancillary documents. And this would be your power of attorney, your medical, the living will. Everyone thinks of the situation in Florida years ago, kind of having a directive that if I'm in a vegetative state or,
Sure.
you know, say
Right.
certain things, then I want you to end my life in a peaceful manner, you know.
Sure.
So those are really important documents.
You put
I
your
think, to
wishes
have
down on paper.
on paper, and even then sometimes they can be challenged, but you really want to think about who you name in those instances because it's an emotional time and you want to know
Sure.
that they'll do what you want
Right.
them to do.
Right. Right. So I heard a lot of talk about power of attorney, durable power of attorney. What are the strengths and kind of weaknesses of a power of attorney if there are weaknesses?
There actually are weaknesses, especially nowadays. And the power of attorney, if for some reason you become incapacitated or unable to manage your own financial affairs, it appoints someone else to manage them for you.
Okay.
And you take the paper, it can be durable, which means it's always in place. So if for some reason you're on vacation, you need someone to help sign, they can do that. Or springing, which means it only comes into place if you are incapacitated and you have so many letters by doctor. But what we've kind of started to run into today is financial institutions are no longer accepting them. They want their own version signed.
Oh, wow.
And
okay.
I don't know if that's just fear of fraud and identity theft these days or what the real reason is, but they're stepping in. We've had clients who have powers of attorney. They've developed early Alzheimer's. We've submitted them to the custodians, and the custodians have come back and said, no, you need to sign our form. And we're like,
Yeah,
we
right.
can't. So the most important thing they go to is tax matters. So if you have them, make sure that it covers tax
Okay.
matters.
Speaking of taxes, okay, everyone's heard of the estate tax or death tax, as some people call it. How does the estate tax work?
Sure. So right now, and we're kind of in flux, but right now everyone has $5 million that they can give away to the next generation tax-free if they pass away early. Otherwise, if you have more than that $5 million, then they're going to start aggregating all your assets and then putting a tax on it.
Okay,
And it's kind of scaled, and the highest tax is at 35% right now.
okay,
And it's just basically, I mean, think of it as an inheritance tax or whatever, but it's taxed on your estate, not to the people that necessarily get it, but paid
Right.
out of your estate.
exactly. Okay, all right, great. So back, I'm jumping around a bit, but back to wills and trusts. People kind of get confused, I think, and they think that maybe a trust is always better than a will, or maybe you can talk about the difference between the two and which one's right for which kind of individual. Yeah.
It just varies. You know, a lot of people like the trust because they're more private. It's harder to contest a trust in the court and the directions put in place there. But if you don't have a real, I would say, robust net worth that you're kind of giving away to the next generation, it might not be as big of a deal. You'll be less likely to have a contested will. So you put the will together, go to court, and distribute your assets. Trusts are a great way to give wealth to next generations, and also a great way if you happen to be in a same-sex relationship to give wealth to your partner without having family members or something step in and try to contest it, because it is more of a private document set up and established.
Sure,
for
it
that.
avoids probate.
It avoids probate, yes. And
Yeah.
it also helps in that power of attorney situation, too, because if you have everything kind of set in the trust and you can't serve, then the successor trustee just comes up and starts serving, which makes it a little easier
Yeah, absolutely.
as well.
Yeah, well, that's good. So let me ask you a question. Let's say I have a client, or let's say that I have a student let's say they have $1 million life insurance policy or $500,000 life insurance policy, and they've named, who do they name as the beneficiary if they want it to go to their kids? I mean, it's not legal advice, it's just education, but I mean, do you see any problems with that, naming it just to the child?
It could, especially if the child is younger, or if you know the child hasn't really developed those astute financial characteristics. You don't want them to go in and just blow it and immediately buy a Lamborghini or whatever it is, you know, because they
That'd be
came into
pretty
some
cool, but
funds.
yeah.
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 And then you know your children best, but especially if they're, you know, I would say, you know, maybe wait until they're in mid-20s, 30s before they really get control of it. And you can leave it to a trust.
Right.
And you name a trustee, someone that you value their decision making, and say, you know, you can kind of manage those funds in this trust vehicle for my child.
So you could set up a life insurance policy for the beneficiary to be a trust.
Correct.
And the trust could say, basically, you can have funds or income for certain things, and the trustee is the one that decides on that. And then you can pay it out at ages, right?
Right, you can
So-
pay it out at ages, or they could become their own trustee of it at certain ages, because there are some advantages to
Right.
trust. There's creditor protection and other
Sure.
things.
Sure. Yeah, absolutely. So, I see what you're saying. You don't want to give $1 million to an 18-year-old.
Not usually.
Not
Unless
usually.
you have a really...
I know some of you are like,
Yeah,
it could never
really
happen to my
solid
kid. My kid
18-year-old.
would never go and spend $1 million. But, you know, look at the statistics of lottery winners. Okay, so let's talk about a couple other quick things real quick, and we'll end it. If I had to say, if you have a client that comes to you immediately with a family, what's the very, very first document you think that's important?
If they've got children under the age of 18, either a guardianship appointment, which
Okay.
you can do without a will, or going ahead and developing that will where
Okay.
you appoint a guardians for
Right,
the
because
children.
I could see there would be a lot of conflict between maybe one of the spouse's parents and the other spouse's parents. Who's going to take care of the kid? And you don't
Right.
want any type of legal battle in that.
You don't.
So
And
first and foremost, protect the kids.
protect the kids, because otherwise the court will decide who
Okay.
gets to raise your children. And a lot of people may disagree with what the court would have appointed.
Absolutely,
So,
absolutely. You're leaving it up to a judge now to make a decision. And they don't know the family really.
or the
so-
dynamics, really.
Right, exactly. What would be kind of the next document, and also, what would, if they go out to an attorney, do you know a ballpark of prices they might pay? I know it's putting you on the spot
Yeah.
here, but I mean, it might be expensive. I'm not sure.
It could be, and it just depends on who you hire. All attorneys kind of have different hourly rates,
Hmm.
and a lot of times that's how they charge. There's some that might do a package deal
Sure.
for a certain amount, but I see typical rates from attorneys ranging from $250 an hour to as high as $600 an hour. It just depends
But if
where
you're,
you go and how much experience they have. Are they board
Right.
certified?
but if it's less complicated, let's just say it's the basic will, the basic durable power of attorney,
Ancillary documents.
ancillary documents, probably on the lower side.
Probably on the lower side. And, you're still probably going to spend over $1,000 to get it all put
Okay.
together, but
Okay, so let me throw this here at you. And let me get your opinion of this. Intuit, the makers of TurboTax,
oh,
okay, have I don't know if you know where I'm going with this.
I do.
Okay, they have a program called Willmaker.
Yes.
Okay, this is my opinion as a financial planner and instructor. It's better to have something than nothing. I'm not endorsing that company or anything like that. What are your feelings towards someone
Towards
doing
that.
their own estate plan using software?
I do agree it is kind of better to have something than nothing, but I will say be careful when you use the software, because they don't always catch everything.
Right.
And that's the challenge. So especially
They're
in
kind of like a
situations-
cookie cutter,
They're kind
one shoe fits all kind of program.
Yeah, and they got to be careful. Like, there's been instances where attorneys have gone in and said, oh, you know what, this doesn't allow for independent administration, which is a great thing in Texas. That means you can probate a will without having to go to court for every single decision you make. If you don't put that in the will, you don't get it.
Okay.
And Texas is kind of unique there. So, and you've got someone trying to put together wills for all 50 states
Okay.
and trying to know every nuance of that state's law.
Okay.
So things could get missed, and it especially starts to happen when you have second marriages, those kind of things. You have children from two marriages, etc.
Okay.
It starts to get iffy.
So you don't have $1,000 to do an estate plan. You're skeptical about using the Intuit's Willmaker or any of the software out there. Is there a handwritten will?
You can
What
do-
can work? Does it work? Is it a good thing? I mean, is it a good thing just at least have a handwritten will saying this is my wishes? I mean, does that work?
It does work to some extent. It's still better, and the courts will acknowledge it. It has to be 100% in your handwriting.
Okay.
I mean, from start to finish. You can't have a print anywhere unless something's changed since I was in law school. And they do. It's held up in courts
Okay.
in times past. You might be missing some of the specifics, but as long as you get in there and you write it down and say, at least, these are the guardians I appoint for my children. This is where I want, my car to go or whatever it
Right.
is. A lot of times
Right.
they'll honor pretty much as much of it as they can.
Okay. Well, so in the class we've talked about taking really small steps in financial planning. It's like going to the gym, as we talk about. You never want to work out really, really hard the first time, because then you'll get sick and you'll never come back, right? So as we talk in class about accumulating wealth slowly and managing a portfolio towards our goals, remember that an estate plan is extremely important, because as Dusty with us today has told us, that what's the most important thing is, if you have kids, who's going to take care of those kids? Okay, who's going to take care of those kids? And if you have an 18-year-old that gets $1 million dropped in their lap, are they going to spend it all? So using trusts, wills, and ancillary documents are very, very important. And I hope you take time to go through the lecture on these documents. And I want to thank Dusty for coming in and
Thank you for
giving
having me.
us some information. And it's very valuable, and we appreciate it.
Thank you.
Thank you.